the fact that the Supreme Court decided to take this case at this time tells us a couple of things. Number one, it tells us something about our Congress. Since 1992, when the physical presence Quill doctrine came down, the court was very clear. They said that Congress had the ability to act and do something differently, should they so choose. They have not so chosen in the intervening 2+ decades since Quill was decided. So it tells us Congress hasn't had the appetite or the ability to move in this space. Number two, since the Supreme Court has the authority to choose or to choose not to take cases and put them on their docket, it tells us that they have something to say. Whether what they have to say would be to affirm the Quill doctrine and put all of this stuff to rest, or whether they choose to overrule the Quill doctrine and adopt a more economic-based nexus standard in its place, really remains to be seen. I've read a lot of the prognostication and a lot of the analysis, and of course I have my own thoughts, but really I haven't seen any definitive thought one way or the other. So in other words, if you're putting a Vegas line on this, I kind of put it even money both ways. It's interesting that this case comes to the court based on a law that was adopted in South Dakota. One, there's kind of a synergy to it that Quill, of course, originated in North Dakota, and this case, which could potentially overturn Quill, comes up through South Dakota. But substantively, what makes this interesting is that South Dakota, out of all the states in the country, has a particularly straightforward and simple sales tax law. And the way they made it straightforward and simple is that they really created a set of rules that apply to everything that's bought and sold. They have some exemptions, they have some exclusions, they have local tax, but really South Dakota is a very straightforward sales tax to apply and to report and to comply with. Contrast that with other states that have also adopted economic nexus rules or have attempted to do so, and they have more complex sales taxes. For example, just before South Dakota enacted their rule, Alabama enacted a rule, and Alabama's taxes are incredibly complex. So what they tried to do to overcome that is they enacted some simplifications to their sales tax that would apply to sellers who only have economic nexus as the necessary precursor to creating an economic nexus rule. So I think when the Supreme Court looks at these facts and they look at South Dakota's sales tax, at least it'll partially play into their reasoning and judgment that South Dakota taxation isn't particularly burdensome tax to comply with. The other thing that makes this time and place for this case interesting is that just a few months ago, the Commonwealth of Massachusetts enacted a regulation. Well, first they enacted a rule, which they revoked, and then they enacted a regulation, which is being legally challenged, which really, in a very novel way, tried to take the Quill physical presence standard and apply it in a way that it would capture virtually all e-commerce companies. And the way they did that was they essentially said that when you have software installed on a customer's device or a computer, then essentially you have property in that jurisdiction, and that triggers classic physical presence nexus as defined by the original Quill doctrine. And really that argument is very compelling, and I thought at the time extremely interesting in terms of it being challenged and how that challenge would go. And the reason why it's interesting is that it's indeed the case that Massachusetts and a bunch of other states, when they moved to tax electronic software and software in the cloud, they did it in a way that said software is in fact tangible personal property. So their own laws are consistent with this idea, and it's also consistent with business practice where software is never really bought and sold, it's licensed. So it's very hard, or given away. It's very hard for a technology provider who may indeed deposit cookies on a customer's mobile device or computer in the state to argue with clean hands, the idea that they don't own that software, that it isn't actually property located in Massachusetts. They may argue it's de minimis property, but it's property. And where all this is going is, I think, to some extent, whether it's overtly or behind the scenes, this may play into the way the Supreme Court receives this case. Could they in some way think that, well, we could decide this case and make a stand on economic nexus, but do we really need to? Is it possible to take the existing Quill doctrine and use it to address this incredibly important and growing concern of commerce escaping taxation and causing states to struggle with tremendous budget shortfalls? Essentially, while not technically moot, it could be that they think the issue is practically moot because the existing law gets the country and all the states where they need to go. That's another open question as to when, let's assume for now that the court does indeed overturn the Quill doctrine. The next question is, well, how will they do it and how will that be organized? Really what was interesting is that all the legislative attempts that never went very far to override Quill had a very clear plan and a timeline as to what states would need to do in order to apply Nexus based on economic standards and when they could do it under what timeline. I don't know what's going to happen in the context of this court decision. What's interesting is that there are at least a couple of states that have these rules that are either in direct legal challenge, much like South Dakota, except they're not as far along, or they have rules that have baked into the law that said this rule becomes effective the moment the Supreme Court makes a decision that overturns the Quill doctrine. So in other words, they wrote into their law, we have this law taxing remote commerce, but we're not going to enforce it until the court says we're allowed to. So really what's an interesting question is, well, what will the court say in their opinion about these laws and about states' ability to enact economic nexus rules? Will it be in the Wild West? Will states be able to do what they want when they want it? Or will the court in some way kick it back to Congress and ask them, again, to articulate a standard as to what would be the necessary predicate actions to allow a state to enact an economic nexus rule? So really it's a wide open question, and probably one of the most interesting questions as we look forward to a Supreme Court decision on this case. So it's interesting, manufacturers have very challenging sales tax obligations. Number one, because they find themselves in a unique position in the supply chain, a spot where a lot of exemptions and exclusions take place, because states favor, a lot of states favor the activity of manufacturing because it creates jobs and boosts the state economy. Right now, manufacturers they expend a lot of energy on making sure that they're able to self-assess use tax when their suppliers don't charge them tax. And of course, a supplier wouldn't charge a manufacturer tax in those circumstances where the seller doesn't have nexus in that state. If this were to come to pass and sellers had nexus in more states, they would be potentially charging manufacturers tax in more circumstances. And if that was the case, manufacturers' concerns would shift a little. They wouldn't necessarily be as concerned with self-assessing use tax when appropriate, but they would have to expend a lot more energy in validating the propriety of any tax charged by their vendor. In other words, to put up sort of an AP or an AR validation tool to make sure that they're only paying as much tax as they should have. And of course, the other thing we're seeing about manufacturers is that they're selling multi-channel, meaning they're selling in the context of their supply chain, and they're charging and they're selling to consumers. If indeed we had an expanded nexus rule, these manufacturers with potentially limited geographic and nexus footprints would indeed have an obligation to collect and remit tax in potentially ultimately any jurisdiction in which they sell. So they have a greatly expanded sales tax obligation.